For over a century, intellectual property law has rested on a single strict requirement. To earn legal protection, a work must carry the imprint of a human personality. Someone has to make free, creative choices. Today, artificial intelligence bypasses that human element entirely. A machine can generate polished software architecture, compelling essays, or highly detailed artwork in a matter of seconds, without a human mind steering the specific brushstrokes or writing the syntax. This creates an immediate legal vacuum. If a machine builds a piece of software, who actually owns the rights to sell it? And going a step further, did that machine legally acquire the millions of data points it used to learn how to code in the first place? To solve this crisis, lawmakers and courts have had to divide the machine into two entirely separate legal halves: the input, where the machine consumes training data, and the output, where the machine generates a new asset. Understanding the strict legal boundary between what an algorithm consumes and what it produces is now the only reliable way to protect digital ownership. Let's start with the output half of the equation. This is the final product that the artificial intelligence generates after you type in a prompt. The legal reality here is harsh. A work purely generated by a machine lacks a human author. Because there is no human author, it falls into a legal void. It receives absolutely zero copyright protection. We have to contrast that pure generation with what we call AI-assisted creation. If you use artificial intelligence strictly as a tool, if you direct it, select its best parts, and heavily edit the final structure, your specific human choices are protected. The copyright covers your layers of effort, not the machine's initial draft. This distinction creates an immediate financial trap. If you rely entirely on pure AI generation, you have no copyright. And if you have no copyright, you have no intellectual property rights to sell, license, or transfer to your clients. That lack of ownership carries direct tax consequences. In jurisdictions with favorable tax regimes for copyright income, like Belgium, claiming those benefits requires you to actually own a protected work. If you generate deliverables with a prompt and minimal editing, you legally disqualify yourself from these tax breaks. Automating your workflow without leaving a highly documented human footprint destroys your financial model. Now we pivot to the input side. Before an algorithm can generate anything, it has to consume massive amounts of existing copyrighted data to learn the patterns. In 2019, a European directive created a specific legal exception for this exact process. It's known as text and data mining, and it allows machines to scrape, analyze, and store data from the internet. Look at this text from the Belgian Code of Economic Law. Point 20 authorizes reproduction for la fouille de texte et données, text and data mining. But read the caveat. Scraping is only legal provided the author has not expressly reserved their works. This is the opt-out right. Creators hold the legal power to block AI from using their portfolios as training food. European law allows machines to learn from the public web, but it simultaneously arms human creators with a legal veto over their own data. Having a rule on paper is one thing. How do you actually guarantee that a multi-billion-dollar language model respects your specific opt-out request? That enforcement mechanism arrived recently in the form of Regulation 2024/1689, better known as the European AI Act. The AI Act forces new obligations onto the developers of general-purpose AI models. They are now legally required to publish detailed, standardized summaries of the data they use for training, and they must demonstrate how they actively respect those 2019 opt-outs. The legislation also addresses the output side with a new transparency mandate. Any content that has been generated or heavily manipulated by an artificial intelligence must be clearly identified as machine-made. These rules are phasing in right now. The obligations for training summaries and transparency mandates become fully applicable at the 2026 horizon. For the modern digital creator, this establishes a clear rule of engagement. You must rigorously document your human contribution to your projects, and you must maintain absolute transparency with your clients about your AI tool usage. As the 2026 regulations take hold, the machine may generate the initial output, but only your transparent, documented human fingerprint will protect your legal ownership and your tax benefits. Please note, the legal landscape surrounding artificial intelligence is evolving rapidly by the month. This information is educational and does not constitute formal legal advice.